Welcome to this edition of Elder Care Answers. Elder Care Answers provides valuable information for senior citizens and those who love them so we can all be more informed consumers.
Hello and welcome to Elder Care Answers, a show dedicated to finding the answers to our elder care and estate planning questions. I'm your host, Mary Ravazio. Joining me is Doreen Seaman of Seaman Law Offices. Doreen is licensed to practice law in West Virginia and Pennsylvania, where she focuses her practice exclusively in elder law and estate planning. Doreen is also an accredited attorney with the Veterans Administration. Hello, Doreen, and welcome to Elder Care Answers.
Hi, Mary. It's great to be here with you.
I hear that your office is growing.
Yes, it is. Since 2008, we have served West Virginians, but in 2021, we opened an office in Pennsylvania as well.
That's interesting. So why Pennsylvania?
To better serve our clients. With our Morgantown office so close to the Pennsylvania line, we often have clients who are seeking care at facilities and hospitals in both states. And we used to refer out the Pennsylvania clients, but now we can help them regardless of where they're located.
So if a person crosses state lines for care, that could affect whether their attorney in their home state could still help them?
Yes, depending on the issue. Sometimes you need an attorney who is licensed in the state the person is relocated to, even if it's just for a period of time.
I imagine you get calls from Pennsylvania residents who need your help as well?
Yes. So currently we have 3 attorneys at our office. All of us serve West Virginia residents and 2 of us serve Pennsylvania residents.
Now, I know that you work with veterans who believe they were wrongly denied for disability compensation, as well as the aid and attendance improved pension. But do the veterans you assist have to be residents of West Virginia or Pennsylvania?
Actually, no. I can assist any of our United States veterans with their VA pension or compensation, regardless of where they're located, because I'm a VA accredited attorney. But if they also need estate planning assistance, I can only work with those who are residents of West Virginia and Pennsylvania.
What does it mean to be a VA accredited attorney?
Well, for an attorney to assist our veterans with their claims, we have to be accredited by the VA, meaning we complete special training, then we're required to complete ongoing continuing education to remain accredited.
So if somebody is listening now and they want to know if they could try to get disability compensation or apply for aid and attendance, can you help?
Yes, if a viewer wants us to screen their case to see if they might qualify now or in the future, we're happy to do this as long as they're willing to provide some basic information that we'd need for our analysis.
That could be helpful. Sometimes it's just so confusing to try to figure these things out on our own.
Yes, estate planning and elder law issues can be very confusing, and the consequences of our decisions can be quite impactful on our care, benefits, and our assets. So getting information online or from professionals who don't focus on estate planning and elder law can have devastating consequences.
We like easy access to information, the internet, social media, or family and friends, but it sounds like it can be dangerous to rely on advice from sources that aren't familiar with all of our details or up to date on current laws.
Oh, I agree. Every day we get a lot of friendly advice from a variety of sources, but just like we shouldn't self-diagnose and treat our serious medical issues, we shouldn't self-diagnose and treat our estate and elder law issues.
That's a good point. I think we've all convinced ourselves we have a medical condition at some point, only to find out we were wrong.
Yes, but I understand that talking to an attorney can feel like a lot for some people. So for those viewers who have concerns but want more information before they make an appointment with an attorney, they can schedule a free telephone consultation with our intake specialist.
How do they do that?
It's simple. Just go to our website, SeamanLawOffices.com, and click the Schedule Appointment button.
Now, most people think estate planning as just needing a last will and testament to take care of their affairs after they pass away. But I know you also focus on estate planning for your clients for issues during their lifetime, especially if there were a period of incapacity.
Yes, people often come to us for a last will and testament to make sure they don't leave things as a mess for their family, and that's extremely important. But I always want to make sure they've taken care of themselves as well by having a well-drafted financial and healthcare power of attorney should they lose capacity before they die.
Doreen, we frequently talk about the various aspects of estate planning, but I often hear people discuss it as something they need to take care of when they get older. Exactly when should a person create an estate plan?
Technically, when they turn 18. They should at least have a financial power of attorney and healthcare directive in place, because at that age, their parent or guardian can't make legal or even medical decisions for them.
I know it's very unlikely that an 18-year-old or even a person in their 20s is going to need those types of document, but I've seen young adults who lost capacity due to accidents or illnesses, and I'm sure most of our viewers have as well.
Regardless of age, if a person had a car accident or a stroke or some other serious injury or illness, think of the stress on their family who may be trying to take care of their own children and home while trying to work. Now, on top of all of that, they're trying to figure out how to get the legal authority to pay your bills, deal with your insurance company, basically to protect your health and your finances that you didn't choose to protect yourself.
So it sounds like if we're an adult, we should have a basic estate plan.
Yes, it's never too early to plan. Then as your life changes, your estate plan can change as well. It's the initial conversation that seems a little more overwhelming, but we work hard to make it as easy as possible.
If I had a loved one who had a sudden event that affected their capacity, I certainly wouldn't want the stress of going to court to be appointed to take care of their medical and financial decisions on top of everything else that I would be worried about. So Doreen, if a loved one has a car accident or something else happens that results in their incapacity for a period of time, we'd need your office to create a power of attorney for them at that time?
If they have the capacity to understand what they're signing, then they can sign them after the emergency, but that's not ideal.
So how does that work? Do you have to go to them?
Yes, one of our attorneys in our office must go to the facility, explain the documents, make sure the person understands the documents and agrees to them, and we need to make sure they're not being pressured to sign.
And is it more expensive in an urgent situation than if they had planned ahead?
Yes, it's more expensive because we have to work fast, set other matters aside, and it usually means an attorney from our office has to travel to that person. We also often have to bring witnesses and a notary with us, so it's stressful and there's usually added expense. As I said, it's not the ideal situation.
If you go to the hospital or rehab facility or wherever a person who needs help and can't travel to you is located, and you find that they just really don't have sufficient capacity to understand what they're signing, then what?
Well, sadly, we would need to work with the family to go through a court process called a conservatorship.
What's a conservatorship?
The family would hire us to ask the court to appoint somebody to manage all of the incapacitated person's finances. If that person didn't have a healthcare directive appointing a healthcare agent, we would also request a guardianship to have a person appointed to make health and safety decisions.
When you say a court process, that sounds like this isn't just going to happen overnight. It may take some time.
That's right. Now, if a loved one loses capacity and you need us to help with that court process, we're happy to help. But the reason we do this show and try to explain these issues to our viewers is so that they take action now to have the correct documents with the needed wording in place before they lose capacity in the future.
So basically, we have a choice to be proactive now, and the payoff would be that we choose our decision makers and the types of decisions they can make if and when we ever need them to take action on our behalf.
Right. And if you choose not to be proactive, then if and when you do need those documents, it may be too late, and the courts will appoint your decision makers.
Even though it's difficult to think about needing that kind of help, I think almost everybody would want to make those decisions for themselves.
I agree.
So I recently saw some shocking numbers regarding the high cost of nursing home care.
Yes, the average cost of a nursing home in our viewing area is now over $10,000 per month.
So at $10,000 per month, it would be about $120,000 per year. I think that the average person couldn't afford that expense for very long.
You're right. In 2019, the Government Accountability Office estimated that only about 48% of the average Americans over the age of 55 years old had any retirement savings. And for those who had some retirement savings, the median amount was about $109,000, meaning it would take them less than 11 months to spend their entire life savings.
Wow, that's shocking to think about. So, what advice do you have for us?
People need to understand the facts and their options. First, many people mistakenly think Medicare will pay for nursing home care, but it only pays for up to 100 days.
So that's only about 3 months. Is the 100 days a sure thing?
No, it isn't always 100 days. There are Medicare guidelines to determine how many of the potential 100 days a person gets.
Okay, so after Medicare coverage ends, then how do we pay?
Medicare is not intended to pay for long-term care. So once the Medicare limit of up to 100 days for long-term care is paid, the patient is personally responsible to pay for their own care.
Do long-term care insurance products help?
Yes, if you purchase coverage while you're still young enough and healthy enough to qualify. But once you're very ill or advanced in age, you probably won't qualify for this type of insurance.
What if I just don't have the money to pay that high cost of care? What happens to me?
Well, if you have resources, you have to spend those resources until you no longer need skilled care or until you're broke. Once you're broke and still need a high level of care, then you can apply for Medicaid.
Okay, so for the average American who has $109,000 in retirement savings, living in West Virginia or Pennsylvania, and needing skilled care in a nursing home, they may qualify for Medicare coverage for up to 100 days, but then they would pay about $10,000 per month for care. Then within 11 months, they'll probably be broke and need to apply for Medicaid?
Yes, that's a common scenario.
Let's talk about what it means to be broke. What assets count when a person applies for Medicaid?
Well, it varies a bit between West Virginia and Pennsylvania, but generally, an unmarried person can keep a home, a vehicle, a small amount of life insurance, reasonable funeral and burial plot, and in West Virginia, about $2,000 in other assets. But in Pennsylvania, it's generally $2,400 and in some cases up to $8,000.
That's just so scary. I mean, we spend our entire lives saving for our futures, but we could lose it all at $10,000 or more per month until we have to apply for Medicaid. Is there planning we can do to avoid that outcome?
Yes, there are specific insurance products and some types of trusts that help a person get a better outcome.
You already mentioned the insurance. Can you tell us more about trusts?
Sure. An irrevocable trust allows you to choose which of your assets you want to earmark to protect. For example, your home, farm, mineral rights, stocks, bonds, life insurance, or even bank accounts. And you can actually still have indirect access to those assets, so they're not completely inaccessible.
It sounds like if my home or other assets are important to me, then I should get professional advice so I can make the best decision for myself and my family.
Exactly. Trusts can be a great option, but they aren't for everybody. Your best solution should be based on your personal circumstances and goals. That's why we're happy to work through your best options with you during our estate planning consultations.
The irrevocable trust is an important piece of the estate planning puzzle. When Elder Care Answers returns, we'll talk more about irrevocable trusts and gifting. Stay with us. Welcome back to Elder Care Answers, the show that explains how to prepare for your elder care and estate planning journey. Doreen, can you explain to me how an irrevocable trust can be a useful estate planning tool?
Yes, and I'll let you in on a little secret. Since irrevocable trust is quite a mouthful, in our office we've nicknamed it as the box. But of course, we thoroughly explain that it's a trust.
Plus, it's easier to visualize how our box works. It's similar to a safe where we put our valuables, then we lock it up for safekeeping.
Exactly. There are many types of irrevocable trusts for a variety of goals, but when we discuss our irrevocable trust that we refer to as our box, it's usually to protect assets from the high cost of long-term care.
So how does a box help?
Boxes are safe places to hold your assets rather than gifting to family. Plus, they may accomplish some favorable tax outcomes. Unlike children, boxes don't get divorced, addicted to drugs, or pass away unexpectedly. They just sit there and hold your valuable assets.
I like that, but what do we need to know about the box?
Well, every gift, including a gift to a box, has a 5-year look back, meaning that we can't just give everything away today and immediately qualify for Medicaid. Gifts in the 5 years before a Medicaid application could cause a period of ineligibility.
So let's say a person gave away $50,000 within the past 5 years and then needed to apply for Medicaid now. What would happen?
Okay, if the gift was to a person, hopefully they still had that money and they were willing to and able to return it. If so, then we're fine, no penalty period.
But I bet that rarely happens.
It is rare that individuals still have that money and will return it. So in our example with a $50,000 gift, under current rules, there would be about a 5-month period of ineligibility for Medicaid, meaning that once that person was broke, she'd now have to private pay for 5 months until her penalty was over.
But local nursing homes cost around $10,000 per month, so if she's broke and she's on penalty for 5 months, how can she pay the nursing home over $10,000 for 5 months?
Good question. That's a big problem, right? If she had gifted that same money to our irrevocable trust that we call a box, the outcome probably would have been different because the money would still likely be in the box, so we can fix the problem and get her Medicaid eligible as soon as possible.
I understand that gifting to an irrevocable trust makes sense to protect assets, but what about taxes?
Well, the tax impact usually works out well. Usually we draft the trust so that the people creating the trust still pay the taxes on the income from those assets, just like they did before the trust. If they put their home in the trust, they can even still reserve the right to live in it. And if they're a senior citizen, they still get all of the tax benefits of being a senior citizen who owns the home.
But who owns those assets?
Trust assets are owned by the trust, not by the person creating the trust or even the trustee, which is the title we use for the person who manages the trust.
And that's good because, like you always say, bad things happen to good people.
Right. If the trustee personally owned the assets, you'd have the risk of all the bad things that can happen to the trustee. But irrevocable trusts don't get sick or injured, they don't have car accidents, divorces, or develop addictions. They just hold your assets.
Well, that sounds perfect. The trustee doesn't own the trust assets, but the trustee controls the assets in the trust. That sounds similar to a manager of a store who works there but doesn't own the store.
Yes, the trustee controls the irrevocable trust, but the trustee doesn't expose the trust assets to any of the bad things that could happen to the trustee.
For your clients who choose irrevocable trust, do they ever struggle with giving control of the trust to their trustee?
Most don't because they have a trusted family member who can serve as the trustee.
Who is the trustee? Does it have to be a family member?
The person creating the trust chooses the trustee, and it can be whomever they want. But most of our clients choose a trusted family member, such as an adult child. But it could be anybody they trust, including a professional, such as a CPA or bank.
Let's discuss what's probably a common scenario. Mom gifts her house to her irrevocable trust and makes her son the trustee. Then she wants to move to a smaller home, so her son, the trustee, signs the deed and the proceeds remain in the trust. Then the son, as trustee, can use the trust assets to purchase her new home in the name of her irrevocable trust?
Yes, so the plan can change as mom's needs change without affecting her 5-year look back.
That all sounds perfect, but are there any disadvantages? When doesn't this work?
Yes, if mom isn't comfortable with the trustee having that control, then she shouldn't create an irrevocable trust because we don't want her to be worried or upset. She needs to have a trustworthy person serve as trustee, and that person has to follow the trust rules.
But if she doesn't create the irrevocable trust, her assets are exposed if she goes into the nursing home and needs to apply for Medicaid.
Right. That's the trade-off, keeping control of the assets and exposing them to the high cost of nursing home care versus keeping less control and getting asset protection. Most of our clients who have a trusted family member are pretty comfortable with the irrevocable trust.
It sounds like if a viewer is considering gifting or is concerned about protecting assets from a potential long-term care crisis, they should schedule a consultation to see exactly how the irrevocable trust would work for them. So now we understand how an irrevocable trust or safe box works. Stay tuned to Elder Care Answers for more valuable information on how to protect you and your family when Elder Care Answers returns. Welcome back to Elder Care Answers. We've been discussing the importance of your elder law and estate plan, but what about trusts for people with disabilities? Doreen, I understand there is a special trust for a person who has disabilities to help protect their money. Can you tell us more about that?
Absolutely. A person who's born with or develops disabilities during their lifetime often uses certain types of trusts that we call supplemental needs trust or special needs trust to hold assets they may have from sources such as inheritance, gifts, or even settlements to maintain eligibility for their public benefits.
So there are government benefits that serve as safety nets for those persons to make sure that they always have some level of income and medical care, correct?
Yes, and these programs look at the person's assets and income to determine if they qualify for benefits, and if they do qualify, at what level.
If a person with a disability, say autism or Down syndrome, qualifies for SSI and maybe even Medicaid, and they inherit money from somebody such as a grandparent, is that okay?
Well, it's very likely that the inheritance will cause her to lose her benefits for at least a period of time.
But she might not need them anymore if she inherited that money.
Maybe, but if she doesn't have her Social Security income or Medicaid for health care, she's probably going to burn through that inheritance pretty quickly. Then she'll need to reapply for benefits. So the inheritance may not help as much as Grandma had hoped.
Could she just disinherit her and maybe give her inheritance to a family member to use for her benefit?
Yes, but that puts quite a burden on that family member to do that. And remember, bad things can happen to good people.
After talking to you each week, I understand that a myriad of things could happen to disturb that plan. That family member may not use it properly or might even pass away themselves. So what's a better solution?
A special needs trust can hold the inheritance so that it doesn't disqualify her for benefits, and then a trustee can manage the trust for her.
If the person with a disability has any type of windfall, that could disqualify her from these benefits, whether it's an inheritance or a settlement from an accident or any other source. We could set up a special needs trust to protect her benefits?
Yes.
That sounds great. I mean, can other people put money into it too?
Yes, there are slightly different rules for special needs trusts created by another person versus one created by the person with disability for themselves. So it's usually better if a loved one uses the money to set up the trust for the beneficiary rather than giving the money directly to the beneficiary to set the trust up herself.
But even if they mistakenly gave money directly to the person with disabilities, or if that person gets a settlement or something like that, it isn't too late to create the trust?
That's right.
A big part of estate planning involves managing assets, which has me thinking about business owners. Do they have unique estate planning concerns too?
Yes, when we work with small business owners, we often find that their businesses aren't structured properly or that they don't have the appropriate business succession planning.
But if they've run their businesses for years and it has been fine, does it really matter now?
Yes, it probably does matter. Did you know that according to the Family Business Institute, that only 30% or so of family-owned businesses survive into the second generation, and only about 12% are still viable into the third generation?
But business owners work so hard to build their businesses. It's a shame to hear those kind of statistics.
Usually these businesses start just as a dream, but over time the business changes, laws change, even family dynamics change, all while the owner is focusing on building and growing their business. Often they have an idea of what they want to happen when they retire or pass away, but that isn't enough for it to happen.
I'm sure it's difficult to figure out how to handle those types of decisions, so they probably get pushed to the back burner.
That's where we come in. We use our experience to simplify difficult decisions while helping the owner to achieve their goals for the business.
That makes sense. It sounds like dovetailing your business planning with your estate planning should be a really important goal for business owners. Whether we are young adults, retirees, business owners, or parents, how do we know we're making the best decisions when it comes to our estate plan?
Well, there are a lot of little things that can change the advice we give a person, which is why our office tends to ask a lot of questions when we meet a new client. We don't want to miss an important fact about them or their family and have unintended results.
How do you know which issues need to be considered?
Experience and education. We've worked with over 1,000 clients in the past decade or so. Almost every single continuing education course we've taken during that time has been about these types of issues.
That sounds like a commitment to estate planning and elder law.
Yes, it is. Estate planning isn't as easy as downloading a will from the internet. We see those documents every day, and honestly, they keep us in business because we get hired to fix the problems created by people who didn't realize they needed our experience.
And you don't practice in any other area of law?
No, and our office does not litigate contested cases either. We create and update estate plans, qualify clients for nursing home, Medicaid, and VA benefits, obtain conservatorships and guardianships, probate estates, and settle trusts.
Where do we start?
Whether you need an estate plan or you have an estate plan that needs to be reviewed, it all starts with a consultation.
Is there a fee for the consultation?
We offer free consultations for general estate planning. For certain types of appointments where the client doesn't need an estate plan but might just need some practical advice regarding a Medicaid application or how to address a specific probate issue, we usually charge a fee. But our office always lets our clients know in advance whether or not there would be a fee.
So there you have it. Start preparing for your future by contacting Doreen at 304-554-2900. You can also visit their website, SeamanLawOffices.com, to request an appointment, watch more of our television shows, or find other resources to help with your estate plan. Be sure to listen to their podcasts and follow Seaman Law on Facebook, LinkedIn, and Instagram. Thank you for joining us today, and we'll see you next time on Elder Care Answers.